Namaskar viewers and a very warm welcome to this episode of the Indian Lawyer Legal Tips. Today we dive into one of the most powerful debates of our constitution, that is the right to religion, assured to us under Articles 25 and 26. What do these articles mean? What rights have been granted to individuals? What are the rights granted to religious denominations? And how have courts interpreted these rights is something that we are going to deep dive into. Stick around and we shall break it down through 5 landmark judgments passed by the Supreme Court of India and explore where we stand today as far as right to religion is concerned. First, let's begin with understanding what is Article 25 and Article 26. The right to religion, also known as the right to freedom of religion, is a fundamental human right that assures every individual the right to choose, practice and propagate their own faith or belief system without coercion or discrimination. Article 25 guarantees the right to freely profess, practice and propagate one's religion, but subject to public order, morality and health. So what does this mean? It means that the state can regulate religious practices only when they affect society, public morality or health. Meanwhile, Article 26 deals with the right of religion for denominations and gives them the autonomy to manage their own affairs in matters of religion, establish and maintain institutions, and own and administer property. So, in a sense, Article 25 is about individual rights, whereas Article 26 is about religious denominations. Interesting, isn't it? So, let's get started. Now let us go through the important judgments passed by the Supreme Court of India that have interpreted the right to religion. The first and probably a very important judgment has been passed by a bench of 7 judges known as the Shirur Mutt case. This was passed in 1954. It's called Commissioner Hindu Religious Endowments Madras versus Sri Lakshminder Tirtha Swayamvar of Shirur Mutt. Now, what happened in this case was the state of Madras had enacted the Madras Hindu Religious and Charitable Endowments Act, which allowed the state to take over the management of religious institutions and appoint commissioners to oversee their administration. The head of the Shirur Mutt challenged the act, stating that it infringed his fundamental rights under Article 26. The Supreme Court made a crucial distinction. Religion includes essential practices, and these are protected from state interference. However, the state can regulate secular activities like temple finances or administrative affairs. The key takeaway: only essential religious practices are protected, and it is up to the court to decide what qualifies within essential religious practice. This test has shaped religious jurisprudence ever since. Then in the same year, another judgment came up, that is Ratilal Panachand Gandhi versus State of Bombay. Here, a Jain temple manager and a trustee of the Parsi Panchayat funds challenged the Bombay Public Trust Act, saying it violated their rights under Article 25 and 26. The Bombay High Court disagreed with them and dismissed the petitions. The matter went up to the Supreme Court. The Supreme Court of India reaffirmed the principle that individuals and communities have the freedom to manage religious affairs, but the state can regulate secular aspects. So again, the key takeaway: the state must not interfere in religious practices unless they are not essential or are secular in nature. Then came the question of religious autonomy versus social equality, a very important judgment that came out in 1958, Sri Venkat Ramana Devaru versus State of Mysore. The trustees of a temple dedicated to Lord Vishnu challenged the application of the Madras Temple Entry Authorization Act 1947, which allowed Dalits and Harijans to enter into the temple. They argued that the temple was a denominational institution protected under Article 26b. The Supreme Court, after carefully going through all the facts, balanced religious rights with social justice, and the verdict that finally came out was that while denominations can challenge religious affairs, they cannot exclude communities if the temple is open to the public. This was based on 25(2)b, which allows the state to intervene in religious practices for social reform. A very powerful precedent which said that religion can't override equality and dignity of the individual. Now let's jump to 2005. MP Gopalakrishna Nayyar versus State of Kerala. The petitioner was the hereditary trustee who challenged the Travancore Cochin Hindu Religious Institutions Act 1950, claiming it violated his rights under Article 26. The state under this act had taken over the temple administration. The Supreme Court ruled that hereditary trusteeship is not a fundamental right. Fundamental rights protected under Article 26 protects denominations' rights to manage its religious affairs, but administration, finance, and appointments are all secular matters, and the state can regulate these particular aspects. Now, turning to a very important case regarding the right to religion. Indian Young Lawyers Association versus State of Kerala. This is the Sabarimala case 2018. A practice was prevailing which banned menstruating women from entering the Sabarimala temple. This was challenged in the Supreme Court of India. The Supreme Court struck it down, ruling that it violated Articles 14, 15, and 25 of the Constitution. It was not an essential religious practice, and constitutional morality outweighs custom. The judgment obviously triggered a national debate with multiple review petitions. In fact, in one of the review petitions, 2019, Kantaru Rajivaru versus Young Indian Lawyers Association 2020, the Supreme Court has referred the matter to a larger bench of 9 judges, asking what exactly is religious denomination, how far can judicial review go in religious matters, and can constitutional morality limit the freedom to religion. Interestingly, a conflict is noted. In the Shirur Mutt case, the 7-judge bench had said that religious denominations should decide what is essential for their faith. And yet, now in this judgment, the Supreme Court has referred the matter to a 9-judge bench which is yet to deliver its verdict as to what will be the law. Recently, we at the Indian Law and Allied Services had filed a public interest litigation on behalf of our clients, Yuga Tulsi Foundation, which was named as Yuga Tulsi Foundation versus TTT. The petitioners in this particular PIL had taken up the issue that when the Agama Shastras spoke about the worship of Lord Venkatesh at Tirumala in a certain way, why was the worship not being done as per the Agama Shastras? In particular, the issue that was discussed was that the milk which had to be offered to Lord Venkatesh was supposed to be the milk that was produced by indigenous cows instead of the milk that is currently being offered, that is the Jersey cow. The matter was argued briefly before the Supreme Court of India. The court was of the view that this matter should have been taken up first at the High Court level. We, of course, did bring up this argument that the TTT matter was not a matter that was regional but had national importance. However, based on what the Supreme Court of India said, we withdrew the petition on behalf of our clients and will be filing the same in the concerned High Court. This case, interestingly, was covered by the entire national press, be it the Times of India or the Hindustan Times in the north or the Deccan Chronicle and the Hindu in the south. It was covered by the social media, and there was a lot of debate on this particular case. Interestingly, there are people who were for the matter and against the matter. However, let us see how the matter shapes up in the near future. Now, in conclusion, let me say that Articles 25 and 26 are headed towards serious reconsideration in view of the fact that the matters are now going to be heard by a bench of 9 judges in the Supreme Court of India. The courts have recognized the need for a new framework that would redefine how we interpret the right to religious freedom. How do we balance faith and law? The cases that have been discussed earlier show that there is a continuous tension between protecting faith and religious identity, ensuring equality and dignity, and at the same time upholding constitutional principles. The right to religion under Articles 25 and 26 is not a free pass, it's a balanced constitutional guarantee meant to protect both individual liberty as well as social justice. If you have found this particular episode useful, it would be my humble request that you should give us a like. We would also request you to please share this particular episode with as many people as you can in your peer groups, in your social platforms, and in your WhatsApp groups. We are doing this as a social endeavor and would therefore want to reach out to as many people as we can. With this, I'd like to conclude. Thank you for watching us. Jai Hind. Till we meet again. Namaste.